see if we can get agreement with all the parties on that schedule.
Do you want some time to talk about it
If we could,
before we get started?
I think that would probably be the
Yes.
most efficient way to do it.
Should we disappear, or do you, if you don't want, should we hang out? I can be persuaded that I'm superfluous.
Certainly not the intent. I'm not saying that.
Yes. No, that was the subtext. You're safe, we're off the record. Yeah, so what, I think
5 minutes?
Yeah, five or 10 minutes.
Yeah, look at that. Okay. Go upstairs.
Pardon me?
Or know you under different circumstances.
There you go.
Became 10, but yeah, what can we say?
We
don't
appreciate
count.
that. We need it.
Well, once you go upstairs, people discover that you're there, and all kinds of weird things start happening.
I know the struggle.
Okay, anything before we go on the record, or should we just go on, get started?
Yes.
I'll take that as a, let's move ahead. I'll say, good morning, this is a pre-hearing conference in docket number 8653, investigation into sound levels from the Vermont wind electric generation facility in Sheffield, Vermont. My name is George Young, I've been appointed as hearing officer in this proceeding, assisting me, Linda Fabrizio and Kevin Fink.
We can't hear you.
Can't hear you.
You're gonna talk in a tone of voice, not project. We can't hear you.
No, we don't need a microphone. I'll just speak up a little bit. I'll start by taking notices of appearance.
Aaron Kasicki on behalf of the Department of Public Service.
Denise Anderson on behalf of Paul Brouha.
Jeff Hand on behalf of Vermont Wind, and with me is Andy Robvogel and Sasha Lewis of our office.
Okay, so this is a pre-hearing conference. Primary purpose, obviously, is to talk about the schedule, and under the board rules, there are lots of other things we can talk about, and there are issues. Have the parties started talking about the schedule, or how they're interested in proceeding, and do we have a proposal?
We have had a discussion about, and we've, I think, arrived at a proposed schedule. I think first and foremost, when we look at this proceeding, I think all the parties agree that there's a certain threshold issue here with respect to clarification of at least 4 issues that the department outlined in its October 14, 2015 comments that relate to sort of best practices and standards going forward for sound monitoring. So the department reached out to Sheffield and Mr. Brouha's counsel, and we discussed setting out a briefing schedule on those issues and any additional issues that parties might want to raise to put before the board for the hearing officer for consideration, for clarification. And so at this point we have a schedule that contemplates a briefing schedule, a hearing officer ruling on the briefing on those issues, and then scheduling a status conference as soon as practical after that, so that we can start moving towards the next phase of the investigation.
And obviously you'll pass out a schedule at some point, but let me just ask so that I can understand this. You're assuming that the 4 threshold issues that you've laid out do not require any factual record or hearings, and it can be done directly on paper? Is that the presumption?
That's the presumption at this point, that we think briefing is sufficient.
And I presume all parties are agreeable to that?
We are. We may have other issues to raise that we think can also be decided without pre-filed testimony. We'd like to get clarification on the issues the department raised, some other technical questions, and then also clarification from the applicant's owner's perspective on how, when we move to site-specific testing at Mr. Brouha's house, how that site-specific testing will be conducted and by whom, with the goal of moving to implement site-specific testing in the late spring, early summer of this year. So we will be proposing a list of questions and clarification for the hearing officer on issues raised by the department as well as those issues I just mentioned.
And do I take it that that would occur after the resolution of the 4 preliminary issues or in parallel?
In parallel, this is going to be our recommendation, is we have one initial brief from all the parties on the issues they would like clarification on, reply briefs on those issues, and then a hearing officer decision on issues. You may decide that some don't require clarification or some do, but a comprehensive decision on how we're going to move forward to implement both what the standard is, what it means, and how it is tested and implemented.
Do you have specific dates associated with this that we're ready to discuss, or?
We do.
If I might,
Sure.
Mr. Young, just for the record, we did have a discussion among council with regard to a schedule. And while we have entertained and agreed with the proposed schedule, for the record, on behalf of Mr. Brouha, I just want to state to you, Mr. Young, that it is our position that the record needs no further clarification, that the variables that have been cited by the department in its October comments frankly will make no difference to the ultimate outcome. And I mean, I don't know what you anticipate here today other than arriving at a schedule, but we've set forth our position in our letter, which was considered in reaching the decision to open this investigation in this new docket. And it's our profound position that the fundamental conclusion is that Vermont Wind has brought us here today, and that it is the obligation of the board to make a decision as to whether or not there's been a violation. And in doing so, we think that there has been sufficient data, a reliable record, it's been confirmed by the independent expert, that a two-pronged decision can be made, and that would be is that there is a violation and that penalties should be considered against Vermont Wind. And having said that, we have discussed the schedule that has been suggested, if that is the direction that you're going to be taking this. With all due respect, sir.
Well, actually, what I just heard from you is essentially you feel that you're in a position to essentially make a summary judgment motion under Rule 56. I mean, I'd be happy to entertain such a motion if that's where you want to go. So I guess my question for you is, are you interested in, are you agreeable to the schedule laid out by the department, or actually, since we haven't seen dates, you all know the dates, I don't. But are you agreeable to that approach, or would you like to put in essentially a dispositive motion in advance of that, or in parallel, or as basically part of your brief on the issues raised by the department? I mean, you can do it in any one of those formats. I'm just curious because when I listened to what you just said, you essentially said no factual issues and we win, which is summary judgment as far as I can tell.
You're absolutely correct, and I will let counsel respond to that also. So having heard that, it would be our position that there aren't any factual issues and that it is ripe for summary judgment. Whether that can whether that can occur in tandem, I don't know. That's interesting.
I don't want to tell you what your position is. I'm merely, merely asking here.
Mm-hmm.
Mr. Hand, you had something.
I guess I was going to say,
I do too.
we disagree that there aren't facts in dispute. I think she's obviously free to file a summary judgment motion. There has been no site-specific testing in Mr. Brouha's house. The sound levels at his house are undetermined, and we will strongly dispute that those are uncontested. So if we wanted to do that in parallel, obviously Ms. Anderson will make her own strategic choices. I'm not sure of the value of doing that. We would like to see a schedule that's efficient and that gets us to the heart of the investigation, which is determining the sound levels at Mr. Brouha's house as promptly as possible. And I think the one we've discussed with the parties is reasonable in both resolving the preliminary issues and getting to that point.
Do you have a proposed schedule that you could pass out? Or read me the dates of, just to get some, so I have some idea of what we're thinking about?
Sure, given the changes to the document, it's probably easier to just read you the dates. So under the proposed schedule that I think all the parties are in agreement on, there would be initial briefing by all the parties on all the issues to be considered. And those aren't limited to issues addressed in the department's comments. The briefing would be due February 10th. Reply briefing would be due February 24th. We would then request that the hearing officer make a ruling on that briefing, on those issues that are raised in the briefing, and that a status conference be scheduled 7 days after the release of the hearing officer's ruling.
Just to emphasize one point, I think we were obviously hoping that the hearing officer's decision might come out in the late March timeframe so that we would have time for the status conference and discussion about how to implement any testing from there going forward, with sufficient time to get into the field with that in the late spring timeframe.
Okay. That's useful to know what the goal in terms of timing is. I'll do a real brief heads up is that I'm out most of the first 2 weeks of March. That having been said, I have 2 capable assistants who I was going to have writing this anyway for me. So we'll have discussed and be ready for all of that. So I don't think that I'm volunteering their time very easily right now. So I'll feel guilty about it later maybe. But we should better work on that time frame. Yes.
So I think having considered where we are with that, and having talked to Mr. Brouha, we would file a motion for summary judgment. And having said that, we would be doing that forthwith. And so I think we'll just double track it.
Okay, that's fine. If that's where you want to go, I mean, should I build a schedule based upon that, or should we assume that the existing briefing and reply brief schedule would be adequate for that? Essentially, you would put your motion for summary judgment on the February 10th, on or before February 10th, and then replies to that and other issues would be on the 24th. Or do you want to have a separate track? I'm just trying to understand exactly how everybody wants to approach this. I think we can have 2 separate tracks. We can have 1 track. I don't care.
Well, I guess I'm trying to think of the most efficient way to do it. Because if a motion for summary judgment is filed, and we are arguing that there are no factual issues, the entertaining a further clarification and investigation of variables would be moot, depending upon the board's determination. So it seems that the most efficient route would be to schedule the summary judgment briefing and follow up with, if it's denied, to follow up with the briefing of issues to be considered, which would be presented by the department and Vermont Wind. And at that point, I don't know what our position would be with regard to issues that would need to be addressed, but they certainly wouldn't be as voluminous as Vermont Wind and the department, or at least the ones that have been suggested so far. So I think, having considered it from our point of view, we would suggest a separate track to brief the Rule 56, and then to follow with, if necessary, a briefing of issues that remain.
And if we do that, you would like that then, instead of the February 10th and 24th dates, those should be pushed back until after resolution of the summary judgment? Is that what you're asking for?
That is correct.
Now
Thank you.
that has the downside of postponing any, to the extent that the summary judgment is denied and that there are, remaining issues, it's going to potentially postpone the time when you're starting to move ahead with actual monitoring. And just, is that, because Mr. Hand had indicated earlier they're hoping to get out late spring, early summer. And I just want to figure out where everybody is in the moving pieces.
And that's our dilemma, because whatever happens, we want it to move forward swiftly.
Right.
On behalf of Mr. Brouha, the briefing of the Rule 56 should be completed before we move into the issues. At least that's what we would propose. And I can certainly move the date up for us to file our initial motion prior to the February 10. Fully recognizing the availability, of course I know you have your two assistants, but the availability in March.
Right, well, I mean, I'm thinking, just in terms of other timing, I'm flexible in terms of the schedule. I'm actually here to resolve issues and set a schedule that makes sense. So I'm not wedded to any particular dates or anything else. So if, I realize Mr. Brouha is a lot of the reason we started this investigation. And so if that's your preference, I don't have any particular problem moving sequentially. I don't know about the department and Vermont Wind.
Yeah, if I can just respond to a couple of points there. I'm very concerned that what's being proposed has the impact of delaying substantially actually doing the testing. We would like to have the technical issues resolved and get to testing as soon as possible. For the hearing officer's context, so that you understand, Mr. Brouha has a pending nuisance case in federal court. It appears to us now at this point that he's actually trying to avoid getting testing at his house in a timely manner, so that we can resolve issues that are in dispute here as well as in that federal nuisance case. We cannot agree to a schedule that limits our standard time for responding to summary judgment motions, because that has a very different implication than simply setting a schedule for the rest of this case. So doing them back to back, I think, is a real concern. We would advocate for resolving the issues that are before the hearing officer on the schedule we've discussed. If Mr. Brouha wants to file a concurrent summary judgment motion, that's certainly their right, and we would address that as required under the rules of civil procedure. But we can't limit that timetable. And my hope is that we could get agreement on getting to this testing as soon as possible, which I think is in the interest of everyone, rather than additional delay on issues that frankly are going to be disputed. The standard for summary judgment is pretty clear. I can say without a doubt that I think it is highly likely that the hearing officer will find that there are facts and material facts in dispute that require additional proceedings. So to me, this sounds like a delay tactic, which concerns me and our client.
Mr. Kiseki.
The only thing that I have to add is, from my perspective, from the department's perspective, is that it's important to try to get a substantial amount of monitoring done this summer as best possible. And the schedule that the parties have agreed to coming into this hearing achieves that. From a resource perspective, the potential loss of being able of time to monitor in the summer far outweighs the extra effort that any party might have to put in to brief both, to file both the summary judgment motion and brief the issues that the parties have agreed to brief coming into this hearing.
If I can just concur with that for the hearing officer's additional context. I think none of the parties dispute that the project absolutely is in compliance during windows closed periods of the year. So we're attempting to get to testing at a time that would allow us to understand the sound levels when someone arguably might have windows open, although we're not conceding that it's necessarily appropriate to have windows open for testing. But we want to be in a time period, late spring, summer, where we can test under those conditions.
Thank you. I mean, obviously, it's our position that additional testing isn't necessary. And the purpose of a Rule 56 motion is to avoid litigation, to avoid additional argument. But most importantly, the purpose is to narrow the issues. So while it's our position that no further testing is necessary, we believe that a summary judgment motion would allow the board to consider what the issues are, what they can be, what they are not, and to get them narrowed. From what I understand is we've got 4 variables, we may have more. So it seems it would be a good and an efficient use of time to let that process run its course as it is intended to do. And then, if I might, just with respect to the federal nuisance case, I hadn't intended to bring it up, but it is kind of an elephant in the room here, so to speak. Mr. Brouha has filed a nuisance case, which is a private right of action in the federal court here in Vermont, and pending is a motion to stay that case based upon what happens here today. And it is Vermont Wind's position, as I see it, to the federal court, that it only wants to do site-specific testing one time, and it wants to do it as the board instructs it to do, and then it's going to use that information and that testing and those results in the federal case. Whether Vermont Wind wants to do specific site testing to prove or disprove or to do whatever it wants to do in the nuisance case should have nothing to do with what's going on here. But it does. It now does. And it's because Vermont Wind has put that at issue. But whether or not Mr. Brouha espouses additional testing is not the crux of the nuisance case. The nuisance case is going to go on its own. So it's our position here, fundamentally, that the conclusion is that there's enough testing, there's enough facts, the facts have been validated, and let's look at what those are, and we think it will take care of everything and move on to an enforcement action, but at a minimum, it's going to narrow the issues.
I think I've heard enough, but if you have something more, Mr. Hand, I can, I do listen.
Very brief response. First, I think that the schedule we've set out in terms of determining the issues would serve the same function just outlined as narrowing the issues to what's in dispute and how to resolve those. Also, I just want to make clear that we believe, as this is an investigation which may lead to a penalty phase, that Vermont Wind is entitled under 30 VSA 30 to a hearing. And resolving the issues purely on summary judgment is not legally appropriate in this matter. And so, regardless of that proposed approach, we will ultimately end up needing to have a technical hearing here. And we believe the approach outlined by the department in terms of resolving issues up front, need clarification, followed by actual testing, followed by a hearing on set facts from that independent testing is the most prudent way forward.
Okay. Having heard from everybody, I'm ready to just rule on all of this and set a schedule. Let me explain what I'm doing first, and then I'll give an explanation as to the warrant. I'm going to accept the proposal from the department in Vermont Wind and adopt the schedule they've laid out, which are the dates: February 10th for briefing, February 24th for live briefing, and we'll work on getting an interim order out by the end of March, to the extent possible, earlier if we can do it. And if something happens, obviously, we're not committing to any particular date there, but we understand the needs there. If Mr. Brouha would like to file a summary judgment motion, you're free to file it at any point in time. You can file it along that schedule. You can file it, file it on February 10th. You can file it beforehand. I hear from Vermont Wind that you need 30 days. I take it to respond to that, you think?
We believe so, yes.
We'll accept that. To the extent that such a motion is filed, you and the department can have your 30 days to respond to that, and we'll rule on that as even when we have the motion and responses there too. I assume you would probably want to reply to their opposition or not?
Correct.
10 days after. It'd be 10 days. So they get 30, you get 10 days after, 10 calendar days after any response that these two parties file.
Is it under the 10-day rule?
That's why I said 10 calendar days.
I wanted to clarify.
Yeah, that is. So
I'm going to count weekends.
No, I said 10, that's why I said 10 calendar days, which is, because the 10-day rule is 10 business days. No, I meant 10 do you need 10 business days? Do you want 2 weeks?
No, I can do 10 calendar.
That's fine. I was.
We live by deadlines, as you well know.
Well, I understand. I understand. I did my litigation side years ago, and,
yes.
and now get to tell you guys when to do things, so I can be arbitrary. But seriously, on this one, yeah, that's the reason I said 10 calendar days, is it avoids the ambiguity, so that the rule 6 time limits don't kick in, because I specified that. That's what my intent is.
And I did think that's what it was, and I wanted to clarify, because this is my first time
Right.
with you. So 10 calendar days is fine.
Right. I've done enough of this practice to, I had some idea of, that's why I did it that way. I did say I was going to explain why. The board's asked to look into this issue, and I think at this point we have some parallel issues going on in another proceeding in Georgia Mountain that are also being looked at. At some point, I think we need to move this investigation forward, and the reason I don't really want to delay resolving the preliminary issues to wait for a whole summary judgment process. And let me just say, having read all the materials, I'm not going to prejudge a motion for summary judgment, but it seems to me there are some factual questions out there that may need to be resolved. I'm not necessarily agreeing with Mr. Hand as to what the whole process is, but this is a board investigation, and there's no sort of preset scope of issues or other matters, so it's, I'll certainly be interested in whatever is moved for summary judgment, but it's not clear what could be moved that would be dispositive of all issues. So I think it would make more sense to just run this in parallel. If you want to file a summary judgment motion, feel free to. With that having been said, are there? Oh, I know. I do have one other issue that does need to be resolved. Ms. Anderson, I believe you filed a notice of appearance in this matter. Is that correct?
Yes. Yes, sir.
I think the board's order opening investigation indicated that Mr. Brouha would need to file a motion to intervene if he wanted to participate, and that he wasn't an automatic party. In other words, we weren't treating this as a complaint, this was a board investigation into sound issues related to the Vermont Wind project. Are you planning to file such a motion, or did you?
After what has occurred here today, the answer is yes. Given the nature of the federal case, I did not file one prior to today, and that is why. I think that was the wisest approach. Given where we are today, we will file a motion to intervene, and I will represent to you that I have reached out to both Mr. Kasipi and to Mr. Hand as to whether they have an objection. When I asked about a month and a half ago, they did not. So if I can so move to intervene here in this hearing, I would do so with the approval and no objection from either council for Vermont Wind or for the department.
Based upon that, I'll ask, I would certainly entertain a verbal motion, and if it's unopposed, we can just grant it now. If there is opposition, then I'll figure out what process. Any opposition?
We do not have any opposition to him intervening as to his specific issues. To the extent the investigation is broader than simply impacts on Mr. Brouha's house, we want to understand if they're intervening on those other issues, but to the extent that the intervention is limited to issues raised by Mr. Brouha, compliance of his house, we have no opposition.
I have no objection.
Is that scope of intervention acceptable, or would you rather like?
No, sir. We would want to be an intervener of right in every issue. Full scope to present evidence and testimony on every issue that is going to be presented, not just those that would allegedly relate only to Mr. Brouha's home. I don't know what those issues will be. So I can't agree to a limited scope of intervention.
Sorry, I'm just contemplating. When okay. I can see where this is going to go. I can require a written motion to intervene and allow people to respond to it, and I'm pretty certain how I'm going to resolve this in the end anyway. So I think I'm going to save everybody a bunch of paper unless I get a very strong objection, which is simply grant Mr. Brouha's motion to intervene without limitation at this time. That having been said, if at some point the issues become sufficiently far away from any interest that Mr. Brouha might have, I would entertain a substantive request to limit the intervention. But right now, I don't know where this case is going in terms of what the issues are ultimately going to be, and it's really hard for me to see any way that I could actually fashion any kind of meaningful limitation on the intervention that makes sense. And so that's my ruling. If you guys really want me to go through the process of putting into writing, I'm pointing to Vermont Wind since the transcript can't see I'm pointing. I would certainly listen to it, but at this, I'm pretty sure I'm going to come out no matter how much paper I get first.
No, thank you, Mr. Young. We'd like to preserve our objection to his intervention beyond any particularized interest, but I appreciate the ruling and we will proceed accordingly.
Great.
And I do appreciate it. Thank you.
Anything else further today? Thank you very much for your time. We're adjourned.